Hello everyone, good morning.
Good morning, sir.
I'm
Good
audible?
morning. Yes.
Yes,
Okay. Should we start?
yes, yes.
Yes.
Okay, okay. Uh, so today I plan to take this topic you can see on your screen, that is the vicarious liability. Just to have the better quality, allow me to just put off my video. All right. If you have any question in between, you just raise your hand. I will come to you. Now, this topic I have taken or taking today, just because I feel this is very important topic from exam point of view, definitely, as well as this is the very much demanding topic or litigation I can see in the court of law. Many issues related with the insurance you can see, or mm, uh, the master servant relationship you can see, employer employee relationship you can see, are dealt by this topic, that is the vicarious liability. Now what exactly means the vicarious liability, and what exactly we are going to understand or going to learn out of this topic? You can see that there are many kind of vicarious liability we see in the society, which arise out of some relationship between two persons. That relationship can be of any nature. You can see on the screen that nature can be of the business partner, or can be a contractor subcontractor, or can be employer employee, or parent and child relationship, or the principal agent or master servant. Now this relationship is very much legalized or legally recognized in any of the, by any of the law. So as India, India also recognized this relationship as a legal relationship, and therefore this relationship has to be understood in terms of tort. Like, who will be the liable if one of the relative of the relationship commit any wrong? Now, whether both will be liable or only one will be liable, who will be the liable? That is the issue which we are going to cover and understand in the topic vicarious liability. This particular issue or particular topic, is important because of some reason, and that reasons are why someone is working for another. Okay, why servant is working for master, why employee is working for employer, why agent is working for principal, etc. Now here, if the servant is working for master, and while working for master, if the servant commits some wrong, and if we hold only the servant liable, then I feel that there is some problem in the relationship, because here we can see the master is disown his liability for any kind of wrong or liability for the servant or for the servant act. And that is why this particular topic or particular thought is very important to understand. Let me just tell you the first the meaning of the vicarious liability, thereby you will understand better what exactly I would wanted to say. Now vicarious liability is the liability where the master is liable for the tort of his servant, principal for his agent, partner for another partner, and employer for an employee. Or you can see, a person is responsible only for his own act in a normal situation, but there are exceptional cases like a vicarious liability in which the law imposes on him vicarious responsibility for the acts of other, however blames himself is. Or you can also understand the vicarious liability in terms of a person who committed wrongful act is liable for that. That is again in general terms. But sometimes a person may be liable for the wrongful act of another if that is having some relationship, and that is called the vicarious liability. It's mean, it's very simply when you are working for another, acting for another, and when you're acting for another, by acting so, if some wrong is committed, then a person for whom we are working is liable. That is the, the rough idea of this term, but the vicarious liability. Now, let me come to the point which is very important and which is the basis of the vicarious liability. You can call the principle of vicarious liability, and then again we will come to the part of definition. We need to know first what is the basis or what is the principles which covers this particular vicarious liability. These are the maxim you can see. It's a Q facet per allium per se. Now this maxim says, he who acts through another does the act himself. There's one more maxim called respondeat superior, and this topic, this term, please remember, because there may be a question only on this point. Explain the respondeat superior or discuss the respondeat superior, like that. Q facet per allium per se. It means he who acts through another does the act himself. Now, we need to understand that a relationship between the master and servant is not new to the world. In a history, in ancient times, and the 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 day we know uh, uh, where the business started, or where the the people working for another, we can see there is a relationship exists of the master and servant, and therefore this is the very basic question discuss arises, that for whom the servant is working, whether he's working for himself or he's working for the master. Now this question can be answered in both the ways, right? Like, nothing wrong saying that the servant is working for himself, okay, because he want to earn money, he want to earn food, and that is why he's working. So he has some reason, some object in working. But the question is whether he is working as per his own way, as per his own instruction, as per his own willingness. I'm not talking about whether he's working forcefully or what. I'm saying that whatever work he's doing, whether he's doing for his own satisfaction, for his own benefit, for his, as per his own wisdom, as per his own instruction, as per his own idea. That is the point I'm trying to make out. Servant is paid for the work he is doing, no doubt for that, definitely. But still, everything he is doing for the master, right? And therefore, we can assume whatever servant is doing, it is the master is doing. Only the master is doing through the servant. And if the master is doing through some act through the servant, then it's very natural that the master should be responsible for that act which he is doing through the servant. That is the simple idea behind the vicarious liability. Okay, so this maxim can be called as a basic and the basis principle of the vicarious liability. That, please remember, Q facet per allium per se. Now here again, there's another principle which you can see. It's called the respondeat superior. Now, what is the respondeat superior? Respondeat superior mean let the principal be liable for what? Let the principal be liable for the act of his servant. There are many issues which we're going to discuss now, that who is the master, who is the servant, how to know this person is the master, how to know this person is servant, that we'll discuss. But the relationship between the master and servant, or uh, employer employee, is something different. So here the principal, it's mean the master responded to the master, should be liable for the act he is performing through someone, doing through someone. That is the another principle which is the basis of the this principle vicarious liability. And the very important point why this particular tort or particular liability is imposed on the master or the employer is the public policy. Now, when we try to understand the social condition of the master, financial condition of the master and servant, so no doubt we can realize that the master is in better position to cover, to handle the issues than servant, right? Of course, servant is not doing anything for himself, but still, when we're talking about the public policy, in the public policy, we have to discuss the social condition of the master, financial condition of the master, and it has to compare with the servant. The master is in better position to to answer the issue, to solve the issue, to uh, take the liability or for any wrong, pay the compensation, and therefore also this particular maxim was imposed and understood, and that is why we can see whenever, even though the driver commit a wrong, any truck driver commit a wrong, so whatever the criminal act he has committed, let's say the negligently driving, recklessly driving, that is a part. But as far as the damages is concerned, we hold the master of the truck liable, owner of the truck liable, and if the insurance company take the responsibility, then they are liable. So insurance company, definitely here I'm not talking about the vicarious liability in case of insurance companies, but someone has already taken a liability of his servant, of his employee, that they are working for me, and therefore if something happen by them, wrong happened by them, then I will be liable for that. This is what the public policy which we admitted, which we accepted, recognized, and that is why this principle can be seen as an important principle in the vicarious liability or in the tort. Now let's discuss again what is meant by exactly the vicarious liability, and we'll discuss in detail. Now, as I told you, the vicarious liability is a liability which is imposed on the master for the wrongful act of the servant. And therefore, here the basic question arises, who is the master and who is the servant? This is not a very straight uh, concept we can think. This is not a very simple point to be discussed. This particular issue has been developed as per the change of circumstances, nature of job, and many things. So we cannot have the one definition or one understanding about the master definition or servant definition. It depends upon what is the nature of work. Okay. I will just give a simple example and then we will come to the point of who is a master, who is a servant. Now let's see. Uh, a person, you can call him, let's say, the worker on the construction site. Okay, there are some people working on the construction site, and there is one person who is the boss of them. Let's say the developer, builder. Now all the construction worker are working for the builder, right? Now who will take decision how to construct the building, what to do today, how to do today, right? Who will take a decision? Who will take a call? So definitely the worker will not take a call what is to be done today, how to do that. They will not take a call. They have to act as per the instruction and the direction of the builder or the person appointed by the builder. So here the worker at a construction site has no need to apply their mind. They have to simply follow the instruction of their master, who is the builder or the person authorized by the builder. Right. Now they can be called as servant, and because they are simply acting as per the instruction and direction of their master. These people are getting a remuneration, compensation, or you can say salary in terms. It may be remuneration or it can be salary, but they are getting for the work they are doing for the developer or builder. They are the servant. Now, Come to the another category of the servant. And who are that servant? There is a hospital, the big hospital company, let's say Apollo Hospital, Fortis Hospital, or like that. Now that hospital has appointed many qualified doctors who are MS, MD, and like that. Now here the question is, as per whose instruction the doctor is working, whether the owner of the company is giving instruction to them, to the doctor, how to work in a hospital, or doctors are applying their experience, their knowledge, their expertise, and doing the job. This is the basic. See, both are the servant. The people working at a construction sites are also servant, and the doctor working in the hospital are also servant.
Your
But
voice is break.
it is everybody's. My voice is not clear. I'm audible
No,
now.
yes, yes, you are audible, sir.
Okay.
Yes.
Okay. Now the point I was trying to make out the difference between the servant. They both are servant. Okay, for the sake of a legal term or legal discussion. Can you see a difference between the worker or the servant working at construction site and servant who are doctor in the hospital? Can you understand a difference between these two people, two servants?
Yes.
So doctor is
Now
a professional.
they are professional, definitely. They are qualified, they are professional, but they are still servant of the doctor, right? I mean, hospital. Can we call them servant?
So they are
Yes, in one
servants,
way.
but they are applying their own skills.
Ah, that is all right. That is different thing. But the question is whether they are servant or not. That is the question.
Yes.
No,
Yes.
they are not servant
They are not servant. Why they are not servant?
because they are doing mental skills and with their means they are the skilled person and applying their own knowledge.
So one
Strictly
has
the
autonomy to take decisions and another doesn't have an autonomy to take decisions.
Okay. So
If they're salaried, they'll be servants.
okay. Good, you are participating. Now, very simple thing. That is why I raise the question to whom we have to call servant. Who is the servant basically? The problem, I'm talking very generally. The term servant seems to be very low grade, but the try to understand the meaning of servant. Servant means the person who is serving for another. That is a servant, right? It's very simple one. Servant doesn't mean sevak. It means a naukar in Marathi. The person who is doing naukri, he's a servant. Correct. A person who is getting salary or remuneration for his work for another is a servant. Now, the we are not talking about the qualification, eligibility, expertise of the servant. There are different level people, different servant. But the question is that the question I wanted to discuss with you: who is a servant, and how to understand the meaning or the nature of servant. That is very important in terms of or for the sake of understanding vicarious liability. Okay. So the example I have given about the worker working at a construction site and the doctor working in a hospital. The work of nature, the qualification, their expertise, and the nature of working is different.
Sir, voice is break.
Okay.
Hello.
No, it's clear for us.
Okay. See, there may be some issue from your part. Uh, if everybody is having a problem, then I can see, right? But from my part, I think internet, Wi-Fi, everything okay.
Yeah, yeah.
Sir,
You're
voice is
audible.
break, sir.
Okay. Now, how I
Hello.
can repair it? Okay, just see. Try just adjust. Uh, because I can't help that if my voice is breaking. May I continue now?
yes, sir.
Yeah, you're audible.
Please, sir. Please.
Yes, sir. You are
Yes.
Yes.
audible.
Yes, sir.
Okay, all right. So I was talking about the definition of servant or the nature of servants. I was talking that the qualification, eligibility, expertise, wisdom is something different. There are case to case there are different servant you may be having. So who is a servant basically? Now, in a very simple term, servant is a person who is working for another for a consideration. Consideration, I'm not talking about any fees. I'm saying a salary, a remuneration, because the advocate is also working for a consideration in bracket fee. An independent doctor is working independently and he is charging fee right from his patient. Advocate charging fees from his clients. So we cannot count the advocates or independent doctors as a servant because they are not working for anyone. They are working for themselves. But the same doctor, if working in a hospital, if they're getting a salary, right? So they can be a servant of the hospital. Same way, the worker working at a construction site are a servant for the developer or for the builder. Now here we need to understand a difference between the category of the servant. They both are servant, but their nature of work is different, working style is different, and working conditions are different. As I told you, in the first category, the worker at construction site are not required to apply their mind. In fact, they are not allowed to apply their mind while working at a construction site. They have to simply follow the instruction direction given by their master, whoever the master at a spot. And so therefore whatever happened after the work, if they are giving good quality, bad quality, whatever it be, the that workers are not liable. Nobody will ask the question.
In case, sir, engineer is working at site, engineer at construction site, he is
Yes,
applying his
correct,
mind, right?
correct, correct.
In that scenario, what is the no things should be there?
With the engineer is servant, again the same thing you have to ask: engineer is servant or not. I'm coming on that point. Okay. Now here the worker are not applying their mind, but they are working. They are servant. Now here doctors are applying their mind. They are taking a decision without asking anything to the master, right? Doctor will not ask anything to the master how to make surgery, whether this medicine should be given or not given. They are independent in their work, but still they are servant. Okay. Coming to the point of engineer at work at the construction sites, whether engineer are paid by their master. If yes, then engineer is also servant of the master. Here, engineer may free to apply his mind, take some decisions, but still is a servant and he is allowed to apply his mind. Now, my point, which I am trying to make out, try to understand that point. The point is it necessary that the servant should not apply their mind? Servant should simply follow instruction. Servant should be simply, follow direction. Or servant can apply his mind. Servant can take decision on behalf of the master. Servant can act independently on the master, but for the master. I'm trying to make out the point
Yes,
that
yes.
yes, yes, Mr. Naik.
Yes, actually the servant can apply his mind. No?
Correct.
So
Yes. True. Correct. So try to understand that I was telling in the beginning, okay, you know, gradually, uh, because of some development of the technology, development of the nature of business, nature of work, we have changed the meaning of master and servant. Earlier, master and servant had very clear definition, very simple definition. A, a master is a person who hire and fire the servant, right? And servant is a person who work as per the instruction of the master. This was the specific and very elusive definition of the master servant. But because of the change in the technology, change in the work of nature of working, and the different profession, different business, different activities, we are now bound to expand the meaning of term servant and the meaning of term master, right? The earlier the master has some power, that power is still with the master. I'm not saying it is not, it is changed, still it is there. But uh, the control of the master over the servant is something changed, which was earlier very specific 100%. Now it is not. Okay. So now who is the servant basically? In short, Servant is a person who act for the master, and for that acting he is getting kind of remuneration or kind of compensate salary. Okay, let me use the word salary. He is getting a salary or remuneration, and the work he is working is not working for himself but for the master. That is the simple definition of the, you know, the servant. And who is the master? Basically, the master is a person who has the power to hire and has the power to fire, right? Power to hire and power to fire. Any person who is having a power to hire and power to fire is a person who can be called as a master. So you have to simply apply this test in order to understand whether this man is a master or not, whether this person is a servant or not. Let's have a simple another more example. The difference between the driver and the taxi driver and taxi driver. If you are having a you are having a car and you appoint a driver. That is the one scenario, and you hire a taxi, let's say cab, and there is a, the person who is the driver who is not your driver. Now, what difference you can see here? In a first term, you can see the person who is having a car and who appoint a driver has the power to hire and fire, right?
Yes.
Yes.
And
Yes.
when
The
you
ownership of the vehicle is also a question here.
you can say so, but see, it is not required that just because you are having a vehicle you can appoint a driver. You can simply appoint, let's say you got only the car from your company, right? And you appoint a driver for the car, right? Let's say company has not authorized you to I mean, company is not giving you a driver, only giving a car. Let's assume. Okay.
Okay.
Now, in order to you want you appoint a driver at your own level without company's concern, right? So definitely this is a different case. I can say, if you interpret, it will go to different side. But now you can see the independent, the driver who is a cab driver is the independent person, and uh, when you appoint a driver is an independent person, because when you appoint driver you get a right of hiring and firing, right? But when you appoint when you hire the cab, you don't, you get only the right of hire, not a fire, right? So this way you have to understand the meaning of the master and servant. I was talking about the change of circumstances, the modern taste, and the old taste. All those things are here. Yes, someone has raised their hand. You want to say anything?
Yes, sir. So basically, I have one question. Like
Uh,
private sector, servant is the employee and master is the employer. But like in public sector, say banks or in government job, who is the master?
I'm coming to that point also, because I need to tell you who are the where this relationship is applicable, right? I will tell you that point. It is not about the private and public. Everywhere this relationship is exist. Now let's come to the point what you're telling. But if you understood the meaning of the master servant, then I will go ahead.
Yeah, yeah.
Yes.
Okay.
Yes, yes.
Now it's very simple that now when the master and servant relationship is exist, then how it exists now, is it necessary that every time you have this specific relationship between the to establish master and servant relationship, like there must be agreement, there must be something like that? uh, not always, right? It is not
No.
required that every time you
No.
should require kind of agreement. You know that our day-to-day life we are having many relationship where there may not be any kind of legal agreement, but the practice, their day-to-day life can easily indicate that they are having kind of relationship, something like that. Okay. Now, whether this vicarious liability is applicable only to a person with the two person like who are master servant, or only for public sector where you are employer employee, or it's applicable to the even to the state or to the public sector. You may be aware that in the first year itself, you in the law of contract, you people must be studying the the contractual liability of the state. Have you studied that part? Anyways, There is one very, known principle we study in the Constitution. In a semester two, you will study this principle that is called the tortious liability of the state. Okay, tortious liability. It's mean the state is also under the vicarious liability for the wrongful act of their servant. Now, whoever whoever is the servant or working for a state, if commit any wrongful act, then state is liable for that. You people might have heard many times, the state has been imposed fine when the atrocity committee in the police station, the state is asked to pay damages, right? Any
Yes,
any government person may commit some wrong to anyone, the state has
Yes,
been
yes,
asked to pay damages. Now, why
yes.
for the act of the servant, act wrongful act of the police or any wrongful act of the any government servant, why the state has to pay damages?
because
If the
state owns the organization.
recently you can see that the some bus accident happened, state bus accident, state transport. Now it possible that it happened due to the negligent act of the driver, but still the state has to pay damages.
Right.
Because of vicarious liability.
Correct, because of the vicarious liability, because the state is a master and every employee, every servant is their servant, and therefore whatever act the servant is committed, the master is liable for that. It's very simple, right? It's very simple, and that is why we need to know that thing. Okay, who is master, who is servant? Now here let me again take a pause and ask one question to you. Yes, we are coming to you. uh, the question is very simple. Nowadays the state is appointing many employee on contractual basis, so they are not the full-time servant or full-time government servant. They are on contract basis, but government only appoint them, right? If that contractual basis servant commits some wrong, so still state can be liable, and this is applicable to any other person in a private sector also.
Contractor will be liable.
This
Yes,
is the
contractor will be liable.
No, no.
But since the government will be appointing,
In that case, we have to see the terms of the contract. What the contract is there.
okay. So these are the also question when because we are in the modern era, when we are seeing that the new modes, new methods of appointing the employees, so therefore vicarious liability has to be mold in that way. Yes, Vivek, you want to ask something? Vivek Bharti. ठीक है. All right. Now let's come to the point that just because the relationship of the master servant exists, just because of that, every act of the servant, master is liable. When for which act the master is liable, for which act the master is not liable. These all things we have to understand. Otherwise, if we allow every wrongful act of the servant, master is liable, then the master will be under very dangerous pressure and dangerous situation, that everything done by the servant at whatever time, you know the master will be liable, and the master will be under such a trauma कि पता नहीं अभी इसका सर्वेंट क्या कर देगा और कैसे कर देगा. uh Before that, that point I forget to discuss, because some question asked in between. Master servant, who is the master? So I told you, the person having a power of hiring and firing, right? And the person also having a power of the control. I mean, he can control in different sense, not in a only one terms. But now you can see many times the real employer, the real owner doesn't appoint any employee. Correct. There are, like you are having a department called HR in your private sectors. Now the HR is having a power to appoint, to hire and fire. I'm correct.
Yes.
Now if the real employer, if you can call owner, the real owner has no idea कि उसकी कंपनी में कितने लोग काम कर रहे हैं, कौन काम कर रहा है, किसी को कब अपॉइंट किया, इसको कब निकाल दिया. Still, can we, in that case, who will be the master? Whether the HR department is the master or the real owner is the master?
Real owner.
Correct. So this is not that much, difficult task to understand. But I'm just trying to tell you, okay, we should not take this term, the right of fire, right of hire, and right to control directly. It can be possible indirectly also. Like the real master, the real owner can do so through different agencies. It doesn't mean that he is not actively involved in hiring and firing. He is not liable. He is still liable. The state government, the state government, central government do not directly appoint anyone. They have different departments, but still the state is liable for every wrongful act of the servant. So that is a simple thing I thought I should tell you. Now coming to the different point, and that point is, in what circumstances we can hold the master liable. That is very important point. Okay. Now I can tell you two conditions which is required for holding the master liable. And when I use the term master, I want to say it may be any master. It may be a state or it may be a private person. The two conditions. The first is the act must be wrongful. That act must have been committed by the servant. And number two, which is very important, that act must have been committed during the course of employment. Correct. So the act must be wrongful. Now, what is a wrongful act? I think we people have studied in the first lecture only. Wrongful act means the act which is legally recognized wrong. Correct. The wrongful act must be legally wrong, legal wrong only. So legal wrong committed by the servant during the course of employment, then only the master is liable, otherwise not. It is possible that the act is wrongful, committed by the servant, but not during the course of employment. If it is not during the course of employment, then why master is liable for that? There is no sense, right? There is no sense make out when we say the master is liable for all time act of the servant. So that is why this term is very important. That call is, you know, the during the course of employment. But during the course of employment, this term depend upon again the work of nature. What is meant by the course of employment? When your employment start, when your employment ends. If you are having a specific time of the employment, let's say you have 10 to 5, that is specific work you have to work for your master, then in that case you can say the master is not liable before any act committed before 10 a.m. and any act after 5 p.m. That is very simple. But there are some acts wherein uh, you are working, servant is working all the time for the master. uh, Example, if you are the police, can we say the police is working 24 hours for the state?
Yes.
There are many jobs where, because of some specific direction or the nature of job, a person is under constant duty of the someone. Okay. There some jobs are there where you have a specific time. After that time you are not concerned with the master, I mean, for that job. Some jobs are there where you are constantly working for the master. Sometime because of situation, let's take example, there is one employee working for a master only for 10 to 5. Okay, let's see, he is a engineer, let's assume. He's working only for 10 to 5 for the master. But the master asked him to go to Chennai and let's have a meeting with the another client. Now, when this engineer is going to Chennai from Mumbai, if he reach Chennai and now at 7 p.m. he is in his hotel room. Okay, tomorrow morning he is going to meet the client. Now, if tonight if he commits some wrong, Can we call that as a course of employment or not? And these are the legal questions which we have to understand.
Yes, 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 sir.
You
He will be liable.
you are saying he is in the course of employment, correct?
Yes, yes.
Why he is in the course of employment?
Best because he is on specific task, na, which covers the whole 2 days.
Correct, correct. So that I'm telling you, the nature of the employment and the course of employment depend upon the many situation, that sometimes depend upon the nature of work, depend upon a spatial direction, depends upon other things also, that we have to understand. So whenever such case comes to you, we have to apply our mind and see whether this man was during the course of employment or not. Let me give another example just to secure for the better understanding. And that is something, let's say the workman's jobs in the company start at 8 a.m., and let's say till 3 p.m. or 4 p.m. they are in the work. But the company has arranged the bus which receive them from their house, drop them at the company, again take them back, and again drop them at home. Now the bus come at a 6 p.m. in the their area. Job start at 8 p.m. Now the worker are in the bus, but the timing will start at 8. If at 7 a.m. in the morning in the bus of the company, if they commit some wrong, can we call them during the course of employment? Number two, a person is not coming to the they are not coming in the company's bus. He is going toward the company's job. In between, he commits some wrong before entering into the company premises. Can we say it's the course of employment?
No.
So
These
first
are
is
some.
yes. First is
First
yes.
is yes,
Second is
second
no.
is no.
Okay. So these are some questions which we have to understand, we have to answer legally. There are many cases happen on such issues where the employee was on the way to his job and he commits some wrong, and it was held that because this man was not yet started his work for the master, therefore it cannot be considered as a course of employment. But if he is doing some work for the master, as I told you in the case of engineer going to Chennai, then we can say this person is in the course of employment. So this is something which we have to understand. Now let me just give the another the case which is very important, and you can write down the case. That case is the State Bank of India versus Shama Devi. How to understand the course of employment? State Bank of India versus Shama Devi. This is the case of 1978. Now, what is the case? And it might have happened with you also. The case is this: uh, in a one building, there was the employee of the State Bank of India and the account holder of the same branch. Now, because they were knowing each other, and that lady had an account in SBI, and the person was working in the same branch of the SBI. What she used to do, she used to give some cash to deposit in her account. Sometimes give a check to withdraw the amount, something like that. And that man was used to take that money, used to deposit, and sometimes used to withdraw the check for her. Now one time he did not, he misused the amount given to him, and he did not deposit, or he not did what he was supposed to do. And therefore the issue was arises whether that employee of the SBI had done some wrong, and whether while doing a wrong, whether he was during the course of employment or not. Now what is the basic, the nature of the bank working, or what uh, the client or the customer of the bank are supposed to do. Let's say I'm the customer of the bank. If I want to deposit the money, what I'm supposed to do? There is no rule as I'm telling you, but it's a practice. If I want to deposit the money, it is me who should go to the bank and deposit the money. If I want to withdraw the money, it is me who should go to the bank and withdraw the money, right? If I am giving this to some bank employee to whom the bank has not authorized to do this, he is doing this because we know to each other. Now entrusting this job to my friend or to the bank employee, and if the bank employee misappropriate or misuse that money, can I hold the bank liable for the wrongful act of the bank employee? This was the question arises in the case of State Bank of India of the Shama Devi case. What do you think? What could have happened in this case?
Bank could not liable, sir,
It is not liable, sir.
because outside the bank premises he has done something.
Okay.
Bank is not liable because there are banking hours fixed, and this
Yes.
person was doing it outside the bank and after or before the bank hours. So bank is not liable.
So this was out of the course of employment.
Okay. Okay. See, can we consider this as a part of the work of the employee? What
No.
you you
No,
know
no.
No, no, no.
in the case it was very specific mentioned that when you have a reason to believe that this man may doing it, he's doing for the bank. See, the nature of job, nature of work. Definitely, I told you it. The bank has not authorized him to do that. Definitely, it is very specifically mentioned. Not, but still, he is a bank employee. The money was given to him for depositing the bank, and therefore the court held that the bank is liable for this. Let me just try to make you understand a different case. Okay, in a very simple way. The state bus is having a two employee in one bus, right? One is a driver, another is a conductor. Correct? Now, what is the role of the driver and what is the role of the conductors?
Mm,
Whether role is specified?
yes.
Now the role is very specified. What is the role? The driver will drive with the bus, and
Yeah, to drive the bus safely.
correct, and conductor will collect the tickets and just guide the driver how to drive. I mean, when to drive, when to stop. Right. This is something roughly I can tell. I'm telling you. Now, in one of the case, the at a bus stand, the driver want to take a 5 minute break as per rule. There was a rule that at that bus stand, driver can take 5 minute break. So driver parked the bus at the bus stand and he went for a washroom. Now the conductor thought by the time the bus driver will come, let me just turn the bus to the direction we want to go. Therefore, the conductor himself took charge of the bus and he tried to reverse the bus in order to keep the bus in the direction they wanted to go after break. While doing so, conductor, while taking a reverse, he dashed another vehicle or some another person to whom he is damaged. Now here the question was this: whether conductor, driver, and the state is liable. Whether state is liable for the act of their driver or their conductor or their employee. Now here, what is the course of employment of the conductor? Whether he has any reason to drive the bus?
No.
No.
He has no reason. He was appointed for what purpose? For anything, but for not driving, right?
Hmm.
Now, still, the conductor took charge of the driving. He tried to do that, what I told you. And therefore, the question was this: whether conductor has work as a part of employment or not, and whether the state is liable for that or not. If anything wrong happened with a conductor in a personal capacity is supposed to pay damages, or state has to pay damages as a master. Now, here the question is this: the driver did not allow or did not ask conductor to reverse the bus and keep the bus in right direction. He did not inform him. He did not ask him. Conductor himself did that. But still, let me tell you, it was hailed that the state is liable. You know why state is liable? For some reason. Reason number one: if the bus driver wanted to take a break, what precaution he was supposed to take?
The key should have been removed.
Correct. Correct.
Yes.
It's very simple. You are supposed to take care of your job. You did not, you are should you are supposed to remove the key, and should you keep the key with you. If you keep the key with, in a bus itself, whether conductor was right or not, that different thing. But is it not implied permission given by the driver to conductor or to anyone? Forget about the conductor, anyone.
Yes.
Yes, yes.
So therefore, the negligent act of the employee, which is not a part of employment, no employer want you to commit a negligent act, but that's the part of employment. If you do something, if you assure something that I am doing a job over there, I am a liable, I am responsible for that so and so job, and therefore I will take care of it. Why I should not rely on you? You're working somewhere, I have work over there. I know you're working there, and you are telling me that okay, I will take care of it. Why should I not rely on you? Let me know. Do you have any reason to disbelieve? When the state is not liable, when the master is not liable, when servant is not at all working for them. You getting a point?
Yes.
If the servant is acting negligently, and because of negligent act something happened, why the master is not liable for this? The question is why the banker has taken money or taken check from me. For what purpose they take it? Just deposit in the
Deposit.
bank. Why conductor drive the bus? Only for their benefit, only because he thought, okay, well, let's save the time. So this is called the negligent act. In your duties, regular duties, if you apply your mind and commit some wrong, the employer cannot say, okay, see, I have not appointed this man for this job or this purpose. Whatever it be, you have done this during the course of employment. It may be not the part you are supposed to do, but you did that during the course of employment. If something done, it's the same applicable to the doctor also. हम गए किडनी का ऑपरेशन करने के लिए, उसने हमारा आँख का ऑपरेशन कर दिया, तो मास्टर क्या बोलेगा कि नहीं, उसको तो मैंने बोला था, मतलब किडनी के लिए करना था, डॉक्टर आपके लिए कर दिया, तो ही इज पर्सनल लायबल फॉर दैट. कैन यू से लाइक दिस? द सेम एग्जांपल ड्यूरिंग इन द ऑपरेशन थिएटर. अगर आपका वार्ड बॉय आके कुछ कर दे, उसका काम है वार्ड बॉय का ये काम ऑपरेशन करना? नहीं है ना.
No.
In the operation theater, doctor is the person who should control direction everything. बट मान लो किसी गलती से अगर वार्ड बॉय ने कुछ गलत काम कर दिया, तो डॉक्टर कैन से कि अरे मेरा क्या काम इसमें, मेरी क्या गलती
No. You cannot say.
है ना. सो सेम वे you have to understand that when you are employee of somewhere, and I have a reason to rely on you, and if you commit some wrong, so I have to hold that you as well as your master liable for that act. That is why that case said has been held like that. You can take another case, that is a case called Rajasthan State Road Transport versus Kailash Nath Kothari. Rajasthan State Road Transport Corporation versus Kailash Nath Tripathi.
So Kailash Nath.
Kothari or
Kailash Nath,
Tripathi?
no, not Tripathi, Kothari. Kothari.
Oh,
AIR 1997, Supreme Court 3444. आता है इस केस में क्या हुआ है ना कि एक ब्रिज पे हेवी रेन के कारण बहुत सारा पानी जमा है, और सभी पैसेंजर बता रहे ड्राइवर को कि भाई वहां से मत लेके जा, बट ड्राइवर बात नहीं मान रहा है. ड्राइवर लेके गया, और उसके कारण काफी लोगों को नुकसान हो गया, काफी लोग जो है मर गए. ओके, सो this was held that the driver is liable. It's a very simple case I'm telling you, but I'm just trying to tell you that even driver could stop there. The driver cannot say कि मुझे मास्टर ने बोला है कि इसी बस से लेके इसी ड्राइवर से लेके जाना है, इसी रोड से लेके जाना है. It is not like that. So if you change the route, or if you do not apply your mind and commit some wrong by any way, so master is liable. That is what the case is. One more thing I have to, it's very important, and you can write down that case is known as, the giving lift to another, giving lift to stranger. You know that I will try to cover many point in this point, giving lift to stranger or giving lift to the another person. You know that when the company buses drop their worker, so they go empty to their company, right? I'm audible now, everyone.
Yeah.
Yes,
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 sir.
yes.
Yes.
Yes,
So
sir.
after dropping the worker, the company both go empty to their company or wherever they're parking the buses. It happened many times. You know that it happened Thane also. Like those bus driver and their people give lift to many people and charge money from them. Now whether they are authorized by the company,
No, no.
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 it's happening now. You know that, right?
Yes, yes, sir.
Yes.
अभी एक्सीडेंट हो गया उनका बस का. अब बीच में जो लोग हैं उनको कुछ इंजरी हो गई तो कौन लायबल है?
No, nobody is, sir, because driver himself.
Whether company is not liable for that?
No, sir.
Sir,
Is
the
it not?
Yes,
company will
company
be
is liable.
liable.
The company will be liable as the
Sir,
vehicle is of the
sir,
company.
company is liable. Yes,
Okay.
company is liable as the vehicle is taken and for the parking purpose, no?
Correct, correct. But can company take a defense that we have not authorized our driver to
Yes.
give lift to from anyone, or drop anyone anywhere? We are not authorized. So driver has
Yes.
acted without our permission, without our
No, they cannot take defense.
okay. See, here,
Company can take that defense, sir. Company can take that defense because company is not earning out of this. Whatever is getting earned is earned by the driver himself because of
correct,
this lift.
correct,
So company is not liable.
but why the company is not liable? Just because the company is not earning out of it?
The company is also not authorized him
Company not authorized.
to
That is
do
very
that.
clear case. Company not authorized. Correct.
सर द कंपनी विल बी लायबल क्योंकि ड्राइवर को उन्होंने जॉब पे रखा है ना, भले वो अपने पर्सनल बेनिफिट के लिए अर्न कर रहा है.
Okay. Now here, this is the act which has been. This is a wrongful act done during the course of employment that you have to understand. This is the wrongful act committed by the driver for during the course of employment. During the course of
What it
employment,
is,
if the any servant is working which is not authorized also, still that is the responsibility of the company. You know why? Because the company is supposed to take care of it. Company should take care of it. Why company is allowing him? We can definitely say a company is not aware of. Company is not aware that the driver is working doing like that. But this is not the defense. This is the negligent act the driver is doing during the course of employment. हाँ, अगर ये आपने पार्क कर दिया गाड़ी, गाड़ी पार्क हो गया, आपका काम हो गया, उसके बाद क्योंकि चाबी आपके पास है, उसके बाद आपने फिर गाड़ी निकाली और उसके बाद फिर आप बस लेके जा रहे हो, then you can say the company is not liable in some terms, up to some extent. But when you
uh,
are in the course of employment, then you are, if you are doing any wrongful act, see, try to understand what we are telling, what we are saying, that master is liable for the wrongful act of the servant. Okay, so this is the wrongful act, correct?
in
आपका आवाज ब्रेक हो रहा है सिद्धेश.
such case, I mean, company signs pact with these employees, right, that they shouldn't do such act. What
There may
happens in
be
that case?
there may be many clauses, there may be many terms and agreement, but still It's a part of
Mm-hmm.
controlling. It's a part of supervision.
Okay. Mm-hmm.
Okay.
The
Otherwise, you can
master
see. हाँ बोलो सिद्धार्थ बोलो.
will yeah, master responsible personal done by a, I
No,
mean
Siddharth,
is if an
I'm not getting
employee
I'm not getting
not
your
audible.
audio properly.
Sir, any Is it case law better is there now? in this?
I'm coming on that point. I'm coming on that point.
Yes.
Okay. Yeah.
Is it?
पहले तो आपको
Am I
आप
audible now?
हाँ you are audible. Yes, बोलिए.
Yeah. Can a master be held responsible for any wrong done by the servant uh, outside the office premises, like if getting involved in a fight or involved in a violent act
No, we are talking
on
about
this
the
person?
tort. We are talking about tort. We are not talking about the criminal wrong.
Okay. Okay.
Okay, this is the tort. No, so only the civil wrong we are talking about. If any person during the course of employment also commit a wrongful act, that is a criminal act, master is not liable for this. Master is liable only for the civil wrong, not for the criminal wrong. Okay. Now
Okay, sir.
take
Thanks.
take the case that I was telling about the conductor liability. Take the case that is a Bird, BEARD, Bird versus London General Omnibus Company.
Can you repeat, sir?
Bird, BEARD, Bird versus London General Omnibus Company. Take the another case. Twine, TWINE, Twine versus Bean Express Limited.
Dwayne versus
Twine, TWINE, Twine versus BEAN, Bean Express Limited.
Sir, any Indian case law is there? Indian?
I will discuss Indian case law also. Okay. Now you people might have seen many time the employees work in a such a way which is not the part of their nature or work nature, but still they work using the same authority, using the same power for what they appointed, and therefore it is said that even though they commit some act during course of employment, so they are liable. As for the there are many things which you have to know, that what is the taste of employment and what is the taste of servant, taste of master. That is already is done. Now only few points you please keep in mind, that when we're talking about the master, so the master is a person who is having control, who can doing it for the sake of profit, who is giving a kind of direction, instruction, or who has the right to hire and fire. So this is something I have done. Now let's come to the point of Indian case law, which is also important for our topic. Well, you can take the first case in the Indian case laws. That is Husainara Khatun versus State of Bihar. Now, this is the case wherein the state was held liable for the keeping the under trial prisoner in a jail for a long time without any trial and something like that. It was held that it is a kind of you know the tort committed by, it is of course deals with the fundamental right also, but it was held that it is a kind of tort committed by the state, and therefore the state is liable to pay damages to the prisoners who were held in a jail for a long time than required. You can take the another case, that is the state of Rajasthan versus Vidyavati. State of Rajasthan versus Vidyavati. This is the case AIR 1962, Supreme Court 933. State of Rajasthan versus Vidyavati. In this case, the, the the issue was the husband of the Vidyavati, you know, was died in accident by the government jeep, and that matter was filed before the court. The court held that you know the state is liable for that. Then you can take the another case. It is a uh, chairman railway board versus Chandrima Das. Chairman railway board versus Chandrima Das. It is the case of AIR 2000, Supreme Court 988.
Could you please repeat, sir?
Chandrima Das versus Chairman Railway Board. AIR 2000, Supreme Court 988. This is the case wherein the petition was filed before the Supreme Court seeking damages for the wrongful act of the railway employee. This is the case wherein a lady was raped by the railway employee at Calcutta railway station, and accordingly, the criminal case was filed. Matter was tried, and the criminal matter was going on at his own way. And meanwhile, Chandrima Das, who was the lady of the advocate, filed the case on behalf of that victim, seeking damages for the violation of right to life and the tort committed by the the state employee or the railway employee. This is the case wherein for the first time, the Supreme Court granted 2 lakh rupee damages to that lady. That is a uh, Chandrima Das case. Okay, everybody got the case name? Chandrima Das versus Railway, Chairman Railway Board,
So
Kolkata.
you mentioned that criminal case. I mean, that doesn't come under this, no?
No, no, no. What I told you that the rape was happened. The police filed the FIR, arrested the people, and that case was going on, right? But because they have committed the criminal act, no doubt. But at the same time, they are the state employee, the railway employee. Sorry, so railway
Hmm.
employee has violated the right of the person by it was held that rape is nothing but the infringement of right to life. Okay,
Okay.
and that is why the damages are required. So this case also comes under state liability. See here, who has paid the damages? It is the state has paid damages for whose act? For the act of their servant.
Hmm.
Criminally,
Okay.
state is not liable, but for civil they are liable.
Got it.
Yeah, you can take another case, that is the uh, Nilabati Behera, Nilabati Behera versus state of Orissa. Nilabati Behera versus state of Orissa. It's a case of 1993. Nilabati Behera versus state of Orissa. This is the case wherein the police, arrested 22-year boy, took him to the police station and for in connection with the theft offense, and then his body was found near railway track. So he was arrested by the police for the interrogation in a theft case. Then he was not found in jail. After a few days, his body was found near the railway track, and therefore that mother Liability Behera filed a petition before the High Court, and she got damages by the state. So I'm telling you, criminal act will take its own course, but because the state employee commits some wrong, that is why it was held. They are liable to pay damages, right? So these are some cases of Indian case laws. There are many cases, but all cases not required to be discussed. So these are some cases which you have to understand. Now, only one point, last point. Okay. Now, last point I would like to make for today's lecture, and that is that may be the question in your exam. So take in that way only, and that is the difference between the servant and the independent contractor. Now, here, when you're talking about the vicarious liability, so we have to understand that who is the servant and who is the independent contractor, and what is their liability in case of the tort committed or wrong committed. Okay. Servant, is a person, as I told you, who is working for another under direction and control of their master or their employer. Whereas the independent contractor is working for master, but not under their instruction and not under their control, but working for them, right? So they are independent. They are not like a servant. So a simple example I can give that will the gist of the this point. The taxi driver is an independent contractor. The car driver is a servant, right? You can understand the difference between these two things. This may be the question in exam. You can see that the servant is under the contract of service, and the independent contractor is under the contract for service. You got the point? So contract of service and contract for service. This is the difference between the servant and independent contractor. Okay, now apart from this, let me just wind up in 2 minutes. At the same time, the vicarious liability is applicable to the partners in a different terms, but like vicarious liability is not only about the master servant; it is about the relationship. So two partners, one partner is liable for the act of another partner. Then you can see the parent and child relationship. The parent is liable for the wrongful act of the child. Child cannot be punished. Child cannot be asked for to pay damages. So parent has to pay damages for the wrongful act of the servant. Same way you can see that. Same way you can see that, if any cattle commit a wrong, then who is liable?
Cattle owner.
Yes, cattle owner. So that relationship is very important. So this way we have to understand this topic. I hope you understood. If you have any question, we can discuss.
Sir, I have one question, sir. It is a relation between in a private limited company. Who is liable? The company or the company director?
Can you repeat the question?
In a private limited company or a public limited company, who is liable? The company is the liable to pay, or the independent directors are liable to pay?
No, it's a company. It's a company is liable to pay. Company include everything, right? Company is the master of this. Director is not something. Director is a part of the company only.
Thank you.
Yes. So see this question.
Sir,
Yes.
sir, in case of subcontracting, the liability falls on the main contractor or like the furthermore?
Now you again have to go back to your, the agreement. Because it's a contract of service, a contract for service. Depend upon that issue.
Okay.
Yeah.
Thank you, sir.
Yeah. Now this will be the 13-mark question in your exam. The question number 4. So accordingly, you have to study this topic, vicarious liability, and try to cover at least 3 to 4 cases. You have to mention in your answer sheet. make in order, like what is the reason of vicarious liability, what is the principle on which this vicarious liability is based on, as I told you in the beginning. Then you have to define the master servant relationship and who is the master, who is the servant. And then you have to come to the point in what cases, in what condition the master is liable and when master is not liable, right? So this is something the part of the vicarious liability. Then you can also discuss about the relationship of master servant, contractor, agent, principal and agent. Then you can also refer about the parent and the child or the wards, right? This way you have to understand and you have to refer some case law as I told you, as I discussed in the lecture. Okay. See, I have not made any PPT which you will be helpful to you, but I will see that some notes I can share in some days.
Please, sir, please.
I'll try to see that, right?
Yes, sir.
Uh, yes. Today, now after lecture, I'm going to share the notes of the false imprisonment and malicious prosecution. Okay. Immediately after lecture, I will share that. So thank you very much. आज संडे है, फिर भी आप लोगों ने टाइम निकाला. Thank you very much for your time.
Thank you, sir. Thank you.
Sir, thank
Thank
you.
you.
Thank you, sir.
Thank you, sir.
Thank you, sir.
अरे अभी अभी क्लास में करते लेक्चर.
Sir, there was a request if we could have such more lectures. This helps in the clarity of the subject. Like if other students agree to be.
From first January, from first January, you'll be having a regular lecture, right?
Okay.
So in the classroom only, and I think that now almost your portion is about to over, right? 75%
Yes.
Yes.
portion already done.
Yes.
So we'll be having a Marathi lecture. In a Marathi lecture, it's a kind of a revision lecture only in Marathi language. We'll cover all the whole subject in 2 days or one day, whatever the time is given. We'll try to do that, and at the same time, we'll be having a preparatory exam. In a preparatory exam, we'll discuss the important questions. So that will also help you. उसके बाद भी अगर लगता है तो we'll see that before exam we'll have some online lecture one day.
Okay, sir.
Okay. We'll see that. I'm not committing, but we'll try for that.
Thank you so much, sir.
Thank you.
Okay,
Thank
thank
you so
you very much.
Thank you. Thank you, sir.
much. Thank you.
Have a nice day.